My name is Zelo Safi, and I'm the Senior Attorney in Immigration and Human Rights at Artistic Freedom Initiative. Our organization provides pro bono immigration representation and resettlement support for artists at risk. Over the last several years, and especially this year, we've seen sharp fluctuations in U.S. immigration policy and procedure. These trends have deeply impacted artists at risk and organizations like AFI that provide legal and resettlement support. Administrative backlogs, increasingly high filing fees, longer processing times, and constantly changing enforcement priorities have made the immigration system less predictable than ever. And these changes hit artists especially hard, who have limited financial resources and who may have been displaced by crisis, censorship, or war. One of the biggest obstacles to artists at risk right now is cost, both in time and in money. Filing fees to the US government and processing times have risen dramatically across the board. For example, the EB-1 visa, which puts an artist on the path towards a green card, can take more than a year to process and get a final decision, sometimes even longer than that. The O-1 and P visas, which are temporary visas that allow artists to work or perform in the US, are also taking significantly longer to process this year compared to just last year. Because of these delays, artists that apply for these visas often feel they have no choice but to pay an additional fee for faster adjudication of their visa applications just to get a timely decision, which costs nearly $3,000 in addition to the already high mandatory filing fees. The required filing fees for these visas themselves have also increased in 2024. These filing fees alone can make immigration relief unattainable for many at-risk artists who have few resources or no institutional backing that would provide financial support in paying these fees that typically end up amounting to several thousands of dollars. It creates an inequitable system where the ability to migrate safely to the US depends on one's ability to pay the associated immigration application fees. Asylum seekers also face similar barriers. Up until earlier this year, there were no filing fees for initial asylum applications or the asylum applicant's initial application for a work authorization document. Effective earlier this year, however, there are now fees attached to asylum cases that includes an initial fee upon filing and an annual fee while the case is pending. There's also now a filing fee to apply for the initial work authorization document. USCIS is also experiencing extreme backlogs in asylum cases, which means processing can take several years, even sometimes 5 years or more before an interview is even scheduled. It means artists who have applied for asylum are living in limbo for a long time. And this type of uncertainty and instability can be devastating for at-risk artists. Talent-based visa applications like the EB-1 and O-1 already have incredibly high evidentiary standards. These applications often run hundreds of pages long. But for artists who have been displaced or censored, meeting these evidentiary standards can be nearly impossible, even if they would otherwise be eligible for the visas. Many no longer have access to personal records or documentation of their achievements and work experience, or have had to avoid press coverage or any type of online presence of their creative or professional work due to censorship or fears of persecution. For those in countries where information about art and culture is very tightly controlled, there may be very little trace of an artist's accomplishments at all. What this means is that it can push otherwise qualified artists out of the visa application process entirely. We've also seen USCIS issue requests for evidence for these talent-based visa applications that ignore major portions of the record already included in their application filings. This causes delay in artists securing such visas, which can jeopardize opportunities to work and engage in their field in the US. Another major issue we've seen grow over the last few years, and especially this year, is the challenge of immigrant intent at US consulates abroad. As a result, artists from certain countries, particularly those experiencing instability, face stronger presumptions of immigrant intent and higher visa denial rates, no matter what evidence they submit. This effectively bars some artists from even short-term opportunities in the US, like residencies, performances, fellowships, or study programs. And all of this is happening in a broader climate of fear and surveillance in the US that's growing this year. We've seen a new travel ban targeting specific regions, and there's been an increase in ICE rates and broader immigration enforcement that sends waves of fear through immigrant and artist communities alike. There's also been a significant expansion of digital vetting, with the US government warning of more routine checks of social media accounts as part of immigration application review process, and even searches of electronic devices at ports of entry, which has a chilling effect on free expression. There may even be artists who are afraid to apply for visas or any type of immigration relief in the US because they fear their political opinions or their art could be used against them. As artists around the world face growing displacement due to political oppression, war, and crisis, and as the US immigration landscape continues to shift, it's more critical than ever that organizations like AFI continue to provide vital legal and resettlement support to artists at risk.
Thank you, everyone. My name is Sanjay Sethi. I'm a human rights lawyer and co-executive director for AFI. Thank you, Zelo, for laying out the U.S. landscape so clearly. And what we're seeing in the U.S., a tightening of access, a growing sense of uncertainty, and a climate that discourages movement, is not an isolated phenomenon. It represents a much broader global pattern. Across the world right now, the right to move, to seek refuge, to participate in cultural life, and to exchange ideas freely has become increasingly constrained. For artists whose work often challenges power or questions identity, mobility is not a luxury. It is the condition that allows their freedom of expression to survive. At AFI, we understand artistic mobility as more than a logistical issue. It is a human right grounded in international law, which defines mobility as an essential precondition of artistic freedom. Without the ability to move, the right to create and participate becomes theoretical. AFI's work rests on two complementary pillars: international advocacy and targeted intervention. First, international advocacy. At the United Nations, we have worked to ensure that artistic freedom and mobility are recognized as integral to existing human rights frameworks. Our goal is to make the right to artistic mobility visible within the UN system as a part of the broader right to participate in cultural life. At the European level, we engage with the European Union and the Council of Europe, urging them to expand the concept of cultural rights to include cross-border mobility. In recent years, AFI has contributed to discussions at an EU level, emphasizing that states must treat the ability of artists to relocate, exhibit, or collaborate across borders as a protected democratic interest, not an administrative privilege. This advocacy has one goal: to shift the conversation from facilitating visas for artists to recognizing mobility as a human right, a right essential to pluralism and democratic participation. Second, targeted intervention. While we push for structural reform, we also respond in real time to crises that affect specific groups of artists. This means identifying where national governments are open to humanitarian collaboration and leveraging that political moment to secure pathways for at-risk artists. For example, Spain has recently been receptive to Afghan artists, recognizing that artists not only represent individuals in danger, but an entire cultural heritage at risk of disappearance. For example, we were able to relocate two women featured in the internationally acclaimed film Bread and Roses from Afghanistan to Spain, under the understanding that both humanitarian grounds were applicable and advocacy at a diplomatic and administrative level was helpful. In past years, Germany has also been instrumental in supporting artists from Afghanistan, Belarus, Ukraine, and Iran through cultural residency frameworks. By engaging both in advocacy and targeted relocation, the dual strategy allows us to connect the normative with the practical. AFI builds pressure at an international level while creating routes to safety for those who cannot wait. Across Europe and beyond, there is a reality that has set in. Governments that once championed cultural openness are narrowing their entry channels for artists at risk. Humanitarian programs for artists, temporary protection, cultural visas, emergency residencies remain patchy, underfunded, and politically fragile. Consulates require documentation that exiled artists cannot possibly produce: proof of income, property, or ties to home countries that they may never be able to safely return to. The result is a contradiction. States celebrate cultural diversity in principle, but block it in practice. Because of this, our global advocacy has to become strategic, flexible, and sometimes improvised. We move opportunistically, country by country, identifying openings in law or policy that can be leveraged to protect specific communities. When a government shows interest, we provide documentation, legal analysis, advocacy, and we put forth partnerships with cultural institutions that make the case politically and morally compelling. We've done this with Spain, with Germany, and we've done this in the US. And currently, we're exploring partnerships in Switzerland and Nordic countries to create sustainable relocation pathways for artists at risk. Our work is constrained by the same barriers we seek to dismantle: fragmented legal frameworks and the fact that no international mechanism recognizes artists as a protected category, rigid immigration systems that treat cultural workers as economic migrants, not rights holders, and political fatigue, which has made states reluctant to open humanitarian pathways for new groups, even when persecution is well documented. It's a paradox. Cultural rights are more visible in law, yet the structures that would make them real are weakening. Our response has been to build pathways where none formally exist. We work with universities, museums, and cultural foundations to support artists and sponsor them directly, with European NGOs to document persecution, and with ministries willing to extend humanitarian protection to cultural workers. Each successful relocation, an Afghan filmmaker to Spain, an Iranian artist to the United States, represents not just an individual case, but a model of how law, culture, and diplomacy can work together. Through these partnerships, we are building what we hope will become an international architecture for artists' mobility. Our long-term goal is to turn these ad hoc efforts into a permanent framework, one that embeds artistic mobility into the international human rights architecture. Until then, we'll continue to act pragmatically, case by case, building bridges where governments build walls, and insisting that the right to move is not a privilege, but a precondition for artistic freedom. Because when artists cannot move, ideas cannot circulate. And when ideas stop crossing borders, democracy itself begins to narrow.